And you're good to go, Mr. Hu.
Okay. Well, everyone, welcome to the September 30th, 2021 meeting of the Albany County Legislature's Personnel Committee. Madam Counsel, do you want to start with taking roll?
Sure, Mr. Chairman. Ethier, Kuhn,
Here.
Drake, Grimm,
Here.
Joyce,
Here.
Lakakis,
Here.
Reedy,
Here.
Simpson,
Here.
and Ward.
Present. And may I ask for an excuse for Mr. Ethier? He did have a death in his family that I'm aware of. And I assume that's where he is tonight.
Thank you for letting us know. 7 present, Mr. Chairman.
Great, thank you. So I believe the first item on our agenda is approval of the minutes from our last meeting.
Yes.
Can I have a motion to approve the minutes?
So moved.
I'll make a motion.
All right, second? Okay,
Second.
all in favor of approving the minutes?
Aye.
Aye.
Any opposed? All right, minutes are approved. Madam Counsel, can you read the first item on the agenda?
Sure, Mr. Chairman. Item 2 is public hearing on proposed local law number I for 2021, a local law of the County of Albany, amending local law number 1 for 2013 entitled An Omnibus Human Rights Law for Albany County. And Norma Chapman is here tonight.
Great,
Good
Ms. Chapman,
evening.
do you want to speak on this item?
Well, yes, thank you, Chairman. Thank you for this opportunity to speak on the Crown, on this Crown law. What I'm speaking about is this local law should be known as the Crown for an workplace for the natural hair amendment for Albany County. So, the legislature further finds that despite the efforts to reverse the racist nature hairstyles, including braids, locks, cornrows, twists, actually what it's doing is adding in the turbans of the hair wearing wraps to go on the hair if they're being discriminated in workplaces. So we're looking at, for Albany County, to put this law forward because the state has already done this, but it wasn't included with certain other hair attires as far as the Bantu twists and knots and the turban wraps. So that's all it's doing, is just adding on to make sure that people are not discriminated when they're going in for a job. I did some research on it, and I was looking at it's been going on since 1978. I have different documentation from 78, from 2008, 16, 17, and 18. I could just briefly read something from 2018, if I may, Chairman. Is it okay?
Yes, please proceed.
Okay.
Thank you.
The United States Supreme Court refused that NAACP League Defense and Education Fund request to review a case in which a Black woman, her name is Chastity Jones, she had her her job offer was rescinded in 2010 at an Alabama insurance company. So they refused to let her work, and because she had dreadlocks. So this is just something that a discrimination law that we want to have addressed in Albany County also, because there have been some cases, and I'm just looking to see if we can move this forward and have the committee, have my colleagues to sign on to. But so I think we'll be having for public hearing. And if our majority counsel can explain some more on that, I would like for her to address. Rebecca?
Or Ms. Chapman. So it's essentially, this local law is intended to prevent employment discrimination based on the natural hair texture and or the use of protective hairstyles or turban wraps in Albany County. This would apply countywide. And it would include braid, locks, cornrows, twists, bantu knots, poofs, and afros, in addition to the use of turban wraps. Studies show that Black women are disproportionately affected by the idea that professional hairstyles are the traditional European features and hairstyles rather than Black hairstyles, traditionally Black hairstyles. In fact, Black women are 1.5% or times more likely to be sent home from work because of their hairstyle. Black women's hair is 3.4% or times, excuse me, more likely to be perceived as unprofessional in a recent study that was done. When shown two images of the same hairstyle on both Black and white women, the same hairstyle on a white woman was rated 25% higher in terms of job readiness and professionalism than a Black woman with the exact same hairstyle. So that's from a 2019 study that we found. So there's an obvious issue here. We're looking to extend what the state law does. The state law currently prevents employment discrimination only based on twists and braids. We would like to extend that to include other very common hairstyles so that a person of color's ability to be employed or not to be discriminated against is not based solely on whether they were able to go to a hairstylist for braids or whether they did their own hair or any number of other considerations that are related to that decision. If you have any questions, please let me know. We did add, as Ms. Chapman indicated, we did add language to include the use of turban wraps to the local law as originally submitted.
Thank you.
Could I ask you a question?
Sean has
Yes,
his hand.
please do.
There, I know of, a lot of schools and athletic programs and some businesses that have policies on hairstyles, and it's not discriminatory. It's for anybody, and I certainly know the intent of this law, but I wouldn't. I know a particular school in Albany County that has a hair cutting policy. I know a professional sports team that has a haircut policy. And I know there's some businesses out there that have haircut policies. Now, I think in all cases, they're mostly for men. But how would this law affect those policies countywide, knowing that two of them are right here in the county?
Ms. Chapman, I can speak to this if you'd like.
Yes, please. Yes,
All right.
Rebecca. Thank you.
So the proposed amendment to the human rights law does not mean that a business cannot have grooming policies in the workplace, primarily for health and safety reasons, especially for things like firefighters can't have,
Correct.
beard, long hair, that sort of thing, or safety concerns like wearing hairnets in a restaurant setting, that sort of thing. However, the grooming styles or the grooming rules rather should not directly target hairstyles that are traditionally associated with people of color. Many businesses have grooming rules that specifically ban locks or braids of any kind. That obviously has a disparate impact on certain races. Grooming policies should also have a valid non-discriminatory purpose and be uniformly applied. If a Black person is told to cut their hair, a white person should have the same requirement. What we found in a number of the studies is that Black people are held to different standards. People of color are held to different standards where, as you mentioned in school settings, people have required that Black children cut their hair to engage in athletic competitions, whereas a white child with long hair was permitted to just put up their hair. So that there is, the disparate impact is definitely an issue here. One that they're, I think Ms. Chapman is
I'm the only one here.
Here.
Thank you.
Okay, so as long as the policy is uniform for all and not in any way discriminatory, there should be no effect on these policies. I guess we'd have to look at their policies to be sure.
Yeah, I mean, without looking at each individual policy, it's kind of unclear how they would be affected by this, in large part because many policies do specifically call out certain types of hairstyles that are particularly and traditionally worn by people of color.
Yeah, no, I definitely agree with the concept, but I'm looking at it from a personnel standpoint. It may affect some Albany County policies as they stand right now, and I think we should try to address those before this gets too far, that we address it with them, either our policy or theirs, one or the other. So.
Understood. Mr. Kuhn, Mr. Simpson also has his hand up.
All right,
Is this-
Mr. Simpson?
Yeah, just for clarification, I'd like to read from the New York State law. It says, Section 292 of the executive law is amended by adding 2 new subdivisions, 37 and 38, to read as follows. The term race shall for, oh shoot. The term race shall for the purposes
time.
of this article include traits historically associated with race, including but not limited to hair texture and protective hairstyles. The term protective hairstyles shall include but not be limited to such hairstyles as braids, locks, and twists. Section 11 of the education law is amended by adding 2 new sections, 9 and 10, to read as follows. Race shall, for purposes of this article, include traits historically associated with race, including but not limited to hair texture and protective hairstyles. Protective hairstyles should include but not be limited to such hairstyles as braids, locks, and this act shall take effect immediately. This is May 23rd, 2019. So if there are any local schools or employers that are in violation of this, then they need to rescind their policies to be in congruence with the law.
Well, in the case of the 2 schools, I'm thinking there's 2 schools in Albany County that, just off the top of my head, that are military schools, and they have specific policies. I don't know how they read, but I'm aware of them. And I know that athletic programs typically have policies on hair, and most of it, you certainly don't want a basketball player with hair in their face. And that's not racial at all. That's, all races. And we've seen that.
Mr. Ward, oh, sorry.
Yeah, and I totally understand where this policy is coming from, and I totally agree with it. But I'm just trying to think of how it may affect schools and businesses in our county as it stands now.
I did just want to
Well,
point
may I-
out that
can I
this
ask a
only-
question?
Sorry.
Oh, I'm
This
sorry.
only applies to employment discrimination, not to schools in general or anything like that. That the state law would still apply to those.
Okay, but the state law may affect it. They'll have to look into that, I guess. So, okay.
If I can just sort of ask a question about Mr. Ward's point. If you have a school, or let's take a school for an example, and they have a policy that mandates short hair, right? As I think some military type schools may. As long as they're mandating short hair for everyone, right? Then they would
Wrong.
not be running afoul of this policy. If they're mandating that everyone have short hair, then that would be okay. But the problem would be if they said, certain long hairstyles are acceptable, but others are not. That would run afoul of the policy. But just a requirement that everyone have short hair, regardless of race, would not run afoul of the policy. Am I correct on that, Madam Counsel?
No, you're incorrect. Go ahead. You're incorrect, but go ahead, Counsel.
Okay, as currently written, yes, this policy would, as long as there is no disparate impact, especially one that's intentional, obviously, but it should have, as long as it has a valid non-discriminatory basis and is uniformly applied to all employees, then it shouldn't be an issue. However, there are a number of grooming policies that say things like neat and orderly, and then they specifically prohibit locks or cornrows. Because they presume that those hairstyles are, it's an essentially racist view that those types of hairstyles are inherently messy or disorderly or something to that effect. So this would prevent that type of policy while permitting a policy that does require non-disparate treatment of everyone, equal treatment of everyone.
Well, I am a little confused then, because I believe Mr. Simpson is saying that I was incorrect and that an institution such as a school this policy would prevent a school from mandating just short hair across the board. Am I correct? Now I am confused.
Well, listen, somebody who has dreadlocks is not going to have short hair. The law specifically lists locks as something that cannot be prohibited.
So what they could state is that hair must be 1 inch or shorter in length.
As long as that is not done in a discriminatory way. In the past, studies have found that that has been used discriminatorily to prevent people from having, say, afros. But yes, you could I don't see any reason why you could not mandate that everyone have short hair at, say, if you're an employee at a military school or something to that effect. This policy as currently written would not change that.
That doesn't seem to comport with the reading of the law. The law is very clear about locks, which by definition, dreadlocks are often not short.
I understand, Mr. Simpson. However, you cannot essentially ban or discriminate against someone for having locks or cornrows or any number of braids or similar styles. However, you could, if uniformly done, ban like long hair. As long as people are not being treated unequally,
Right.
as currently written, that is how it is. I mean, if Ms. Chapman would like to reconsider, or if you want to speak to her separately, you certainly could do that and follow up. As currently written, it would not require.
No, I'm talking about how the state law reads. The state law doesn't have anything in it that says there are exceptions for uniform short hair. And I'm saying by definition, dreadlocks are almost universally long, extremely long. And so what you're saying goes counter to the black letter law that's in the state. Now, I don't know if there's some kind of court precedent that modifies the 2019 law, but as a law, right, the interpretation of short hair does not apply to the specifically listed hairstyles in the law.
Question?
I would just note that Mr. Simpson's talking about the state law, but what we're considering here is
I'm talking about the state law, I'm talking about the state's law which supersedes anything that we do in the county. We're doing something in the county to augment, to specifically deal with turbans, which is also important because there are a lot of people who and/or wraps.
You're breaking up, Mert. I can't hear you.
Clarify for the county, but in terms of the specific issue, in terms of the specific issue of a uniform standard of short hair, that uniform standard would allow of same locks policy that says short is what's required. That, as far as the black of the law, would run afoul.
Well,
All right, Mr. Simpson, we can certainly discuss this further offline. You're breaking up quite a bit, so I'm not sure that we
Sure.
can understand your meaning totally.
All
But
right.
this law
Sure.
expands on the ban on discrimination that the state currently has. So it's essentially the same language, except it goes further in banning more types of discrimination based on different hairstyles.
Yeah,
Understood. But what I'm
all
saying is
yeah.
there's an interpretation that's running afoul of the superior state law. That's what I'm saying. I don't want that. I don't want that misinformation to go forward, that there's some kind of qualification that limits the actual intent of the overriding state law. That's the point I'm trying to make.
I understand, and I think we're going to have to discuss this further offline based on the research we've done
Sure.
and the legal interpretation of the state law. Mhm.
Okay.
Thank you.
So where does that leave us today?
God.
Just a reminder that this is just a public hearing as well.
Yeah, I have no
Yeah, I had a
objection.
question about that because there's two agenda items. There's a public hearing, but then the local law is itself the next item on the agenda, isn't it?
Yep, we have to
Yes.
do that. The public hearing would move forward first
The law will be
today,
tabled, yeah.
and the law would be tabled, yes.
Tabled because there's no public hearing yet, yeah. My concern
Okay.
is, just this discussion shows that there may be some holes in the law because it's so confusing just among legislators who have studied the law. I think if you're head of a military school, you have every right to say everybody should have short hair. And I don't think the state law or the county law has changed that. So we make any legislation we have should be really clear about that. And there's other instances, for example, there's a lot of video games now and employees, and I was at a store where you do virtual reality and they have to have headgear. So certainly all employees should be able to have headgear, and the hair requirement should be consistent with the ability to wear a headgear. So
Yes, this law would
I
not
think
prohibit that.
there's a sense from this that, employer can't say anything about your hair. What they're saying is you can't discriminate based on race or ethnicity or anything like that. But if they want short hair, they should be required to have short hair. That's the
Well,
way
the
I read
law,
it.
as I previously stated, you can have grooming rules. You can have a grooming policy. It just cannot be discriminatory against traditionally Black hairstyles or hairstyles traditionally used by people of color. It must be uniformly applied. There must be health and safety reasons that are legitimate. There must be actual reasons for any change. I would note that the military has lifted its ban on locks and braids. The Army removed, they lifted the ban on dreadlocks in 2017 and also removed the terms matted and unkempt from its description of Black hairstyles in their appearance regulations. Also, the Marines have approved braids, twists, and locks back in 2015. So this is not out of the ordinary for a military environment.
But you're saying the military doesn't have any rules on hair length?
Not currently to my knowledge. They
I
have
think
approved-
it's for women. But they don't, I'm sure they have a length overall rule for female soldiers, but
it just needs to be put up in a certain manner, yes.
I think when you go to boot camp, they shave your head. That's my understanding.
I don't believe
That
they
would be
shave the
incorrect.
heads of female soldiers.
All right, so you're just saying they do it to the men? We need this, I think we need some more answers on this. I agree with what Sean Ward is saying. I think if you're in a military school, you should be able to require short hair. That's part of what they do.
And
And I
as I
also think there's
indicated,
the headgear issue this has become more prominent because there's video everything now. And you really need the headgear to be able to be involved in the video stuff.
and as I indicated, both of those are not prohibited by this law.
Well,
Thank
and
you.
I think it should say that I think people would be more comfortable if there's something in the law that made that clear.
Just for information, I did email members of the committee the actual state law, so you could read the law for yourself.
Yeah, well, thanks, Mert. Well, yeah.
Absolutely, and
did-
everyone can follow up with counsel afterward as well to consider that. Mr. Coon,
Thank
did you
you.
want to move forward at this point?
Council, am I correct that at this point, we would be voting to have a public hearing on this law?
Mhm.
Which we should.
And any of the concerns that have been raised can be addressed over the next few weeks, and we won't be for at least a month in a position where we're voting substantively on this. So
Yes,
I
that's
guess,
correct.
I would propose that we proceed with the vote on the public hearing, and
I'll
then
make a
we
motion.
can continue to discuss it. So I heard a motion for that. Do I have a
I'll
second?
make the second.
Okay.
I'll second the motion.
All
I
in
should
favor
say.
of proceeding with the public hearing on this local law, please
Aye.
indicate.
Aye.
Aye. Are any opposed? Okay.
Jeff, a couple of us have to go in 1 minute.
Oh, all right. Well, Madam Council, what else is on the agenda, please?
Item 3 has been tabled pending the public hearing. Item 4 is authorizing a memorandum of understanding with Teamsters Local 294, District Attorney Investigators Unit, and amending the 2021 District Attorney's Office budget. I believe Ms. Orth
Okay,
is
is there
here.
any? Okay, we can hear from her then.
Good evening. I am here tonight to seek approval for an MOU that was agreed upon by our union in the DA's office and the Office of the County Executive moving forward, and the Director of Employee Relations for the County Executive. This resolution, or this MOU would give the members of our union 2% increases for 2019, 2020, and 2021. So it will bring us and our investigators to a current place with their collective bargaining agreements. The increases would be for $4,337 for this year for the remainder, or actually that's the full year amount for each of our investigators. It will be $4,539 for our senior investigator. I have taken the money out of 2 vacant positions that we had during the year. And the increases this year for the full year are budget neutral, even though they will not be fully utilized. We'll only spend about a quarter, a little more than a quarter, probably a third, because this was signed in August of the amount that I've allocated. So there will be monies left on the table for this year, but it will increase the budget by $43,572 for the upcoming year. And starting in 2022, our investigators will not have an active contract and will once again begin negotiations.
Great. Thank you very much. Does anyone have any questions on this item?
So this is all retroactive contractual obligations, and I assume that negotiations for the upcoming contract will begin soon?
That is the hope. We have some contractual things that we'd like to change in the upcoming agreement, both management and the union members. There's just some old language in there that we do want to clean up, but in terms of getting the members current, yes, these are retro for 2% for each of the years, but this RLA does not include the retro amounts for 19 and 20. It only includes the payroll amounts that we will have to increase our budget by for this current year, for the remainder of the current year.
So as far as the budget goes, you had the money budgeted for 19 and 20 somewhere? Is that what you're saying?
I don't. I believe that the payroll department, HR, knows that these contracts are outstanding and has a contingency fund that allows for retro when they know that these contracts have not been signed. So that amount is going to come out of an account that's held by the county. And then the current amount I've found in our budget.
Oh, okay. That makes sense.
Motion,
Okay. Are there any other questions on this item?
motion to approve.
All right. I have motion approved. Do I have a second?
Second.
Great. All in favor?
Aye.
Aye. Any opposed? Okay, motion carries. Madam Counsel, I believe you said that was the last item on the agenda?
Yes, there is no further business.
Motion to adjourn.
Okay. Motion to adjourn. Do I have a
See you
second?
in a minute.
I'll see you in a
All in
minute,
favor?
Lynn.
Aye.